for our citizens, the proliferation of state occupational licensing laws and the effects these have on entrepreneurship and job creation. As the private economy continues to struggle to create sufficient number of jobs to replace those lost in the recession, many unemployed and underemployed Americans are taking it upon themselves to use whatever skills or talents they have to start their own business and earn income. Unfortunately, for many of these would-be entrepreneurs, they may need some sort of government approval in order to do so. One of the most difficult forms of that approval is an occupational license. While the intent of occupational licenses are to protect public health and safety or to protect consumers from bad actors, the scope and complexity of occupational licensing has grown considerably in the last years. Yet as these trends develop, there is mounting evidence that many of the public benefits arguments used to justify occupational licenses are tenuous at best. Instead, some licensing laws appear to designed not to protect life, safety, or property, but to protect existing businesses from competition. For example, while many Americans would not be surprised to know that doctors and lawyers need a state-issued license to practice their trade, they may be surprised to learn that it is illegal for a person to braid hair, work as an interior decorator, or operate an obedience school for dogs without a state-issued license. And they may be more shocked to learn that obtaining these licenses, the work it takes to obtain these licenses. In a recent report, the Institute for Justice found that the education and training requirements for many of these professions to obtain a license exceed those needed to become an emergency medical technician, an occupation where lives are at risk. The cost of such excessive licensing requirements can be measured in reduction in new business startups, job loss, higher prices for consumers, or increased income inequality. According to another study, job creation in certain professions is 20% lower in a licensed state versus unlicensed state. Many of the entrepreneurial opportunities lost to excessive occupational licensing are in jobs that most likely to be pursued by the economically disadvantaged. The issue of state and local occupational licensing raises several questions for Congress. While the federal policymakers have an interest in promoting the principles of economic liberty and preventing discriminatory practices that limit opportunity, especially in the disadvantaged, we must also respect the principle of federalism, which gives states the right to regulate activities that take place within their borders. Our purpose today is not to answer the question of whether states should or should not regulate. It is to examine how certain occupational licensing laws have become excessive and discuss options for reform to enhance the opportunity and help our economy and its people grow jobs and prosper. I now yield to the ranking member for her comments.
Thank you, Mr. Chairman. Licensing is a process by which the state makes it illegal to do a certain job unless one completes a series of mandatory requirements. The requirements are usually set by a licensing board made up of members of the profession or by legislatures with significant input from current professionals. The origin of these limits had promising goals and was intended to protect the safety and well-being of residents. But since the 1950s, the number of licensed workers has jumped from just 5% of the workforce to nearly 30% today. In total, roughly 1,100 occupations now require some sort of license by at least one state. Much of the time, these licenses require fees to be paid, training of some sort, and written examinations. While the requirements serve a functional purpose, they are also a barrier for entrepreneurs to enter an occupation. Today's hearing will give us the opportunity to learn more about the genesis of professional licensing and its evolution. Though this issue is one for the states to take up, it is nevertheless important for us to bring it to the forefront. Licensing requirements have exploded to new fields, some that merit regulations and others that raise the question of whether there is too much licensing. States have broad powers to regulate their workers and have a duty to protect their residents. Requiring certain professions to meet strict licensing rules only makes sense in that regard. However, we must look at the implications licensing has on entrepreneurs. They are the backbone of our economy, and we rely on them for innovation and growth. Requirements for training, fees, and examinations can keep qualified individuals from starting a business or entering a new profession. And a lack of uniformity among the states in their licensing rules impact many entrepreneurs attempting to move to another market where they see an opportunity for business growth. States should not be hindering growth in these viable markets for business expansion or creation. They should be fostering these self-starters. Encouraging competition for small firms is critical to job creation and economic growth. The Sherman Antitrust Act was created to do just that: protect consumers and business owners from anti-competitive behavior. We will hear from witnesses about how antitrust law applies to cases involving licensing boards and what approach is best for ensuring qualified individuals can enter an occupation without fear of excessive costs. Despite the fact that this topic belongs on the state level, the well-being of American entrepreneurs is a concern to the nation as a whole. That's why I'm glad we're holding this hearing. It will give us a chance to hear some personal experiences of those who have successfully navigated state regulations and what insights they can provide to reform the system. As more Americans begin to take risks and start their own businesses, it is vital to bring licensing requirements to their attention. Balancing the need for market competition with the need for consumer protections will give small firms the certainty they require. We are here today to learn more about licensing rules and how to address the possibility of over-licensing. In order to ensure the success of our self-employed, we must understand the challenges and benefits these laws hold for entrepreneurs. I thank all the witnesses for being here today, and I look forward to your comments. Thank you, and I yield back.
Thank you. Committee members have an opening statement. I ask that they submit them for the record. I'll just take a minute to explain to you the lights. It's a little like your stewardess explaining the seatbelt, but you have 5 minutes. We'll be lenient. You'll see the yellow light go on. That's a minute left. And with that, I'll yield to Mr. Nunley from Mississippi will introduce our first witness. Go ahead. You may begin.
Thank you, Mr. Chairman. It is my privilege to be before this committee. Even though I'm not on the committee, I thank you for allowing me to be here with my constituent and friend, Melanie Armstrong. I met Melanie 5 years ago when she was a small business operator, and I was serving in the state Senate. I was her senator. And Melanie was attempting to grow a business, helping to teach other people how to be small business operators, and she was restrained by the process of state regulation. And she came to me as her legislator. Before she came to see me, she had attempted to get relief through the administration and the regulatory process and had not been successful. She then went into the courts, and that process was dragging on too long. And I think if I would ask this committee to take anything away from my part of this hearing, it's that when Melanie Armstrong came to the state legislature, she found a willing ear to listen, and we responded. And within 90 days, we fixed the problem. We put legislation on Governor Haley Barbour's desk that he signed into law. And I would ask the committee to reflect, if she had come to the Congress asking for similar relief, how long would it have taken, and would we still be debating the issue that we solved in 90 days at the state level? I think there's a real reason the states are known as the great laboratories of democracy. So with that, Melanie Armstrong from Tupelo, Mississippi, we are glad to have you here today to testify before this committee.
And Ms. Armstrong, you may begin.
Thank you, Mr. Chairman and members of this committee. My name is Melanie Armstrong. Every day, hundreds of low-income families are housed because of my work, but I don't run a shelter. They are clothed through what I've done, but I don't run a secondhand clothing store. They are fed because of what I achieve, but I don't run a soup kitchen. I've transformed the lives of hundreds of poor women in my state of Mississippi, not because I sought out government assistance, rather because I asked the government to get out of my way. I demanded that the government get out of my way so that I could provide for myself and for my family, and so other women around me could do likewise in peace, dignity, and prosperity. And if a lawn braider in Tupelo, Mississippi could have such a transformative impact, helping to change the law to free so many around to earn an honest living, imagine what could happen across our nation if state and local governments followed that example. Not every entrepreneur is a Bill Gates or Henry Ford. Some are and will remain more humble in the scope of their impact. But each day, we all demonstrate the power of one entrepreneur. African hair braiding is a skill that has been passed from one generation of women to another for the past 3,000 years of recorded history. For the vast majority of human history, women like me have practiced this craft with no government oversight, with no government issued license, and with no government imposed demands. We learned from the previous generations by doing, and in so doing, we were free to earn a living for our families. But even with that history, to open my hair braiding salon, Naturally Speaking, in Tupelo, Mississippi in 1999, I had to file a lawsuit and lobby the state to change the hair braiding law in my state so I could get to work. To get paid to braid hair, many states demand braiders to obtain a cosmetology license or other similar license, typically requiring up to 2,100 hours of coursework. That is more than a year's worth of work study, 40 hours a week taking classes that don't teach braiding. Let me say that again. The government in many states requires would-be braiders to take thousands of hours of classes that have literally nothing to do with the trade they want to practice. To teach others to braid hair in Mississippi required me to take more than 3,000 hours of classes and apply for a school license, hours I could use more productively running my own business. In the 3,200 classroom hours it would have taken for me to earn a license to teach hair braiding, I could have instead become licensed in all of the following occupations in Mississippi: emergency medical technician as a paramedic, ambulance driver, law enforcement officer, firefighter, real estate appraiser, hunting education instructor. And that would have all taken more than 600 hours less than obtaining a license to teach hair braiding. The cosmetology establishment benefited most from Mississippi's regulations. Practicing cosmetologists made up the State Board of Cosmetology, and they did their best to keep competition to a minimum and to ensure cosmetology schools enjoyed captive customers in the form of students. It was in August 2004 I joined two aspiring hair braiders and the Institute for Justice, a public interest law firm that represented us for free. We filed a lawsuit to break down the regulatory walls barring potential entrepreneurs from entering the field. In the months that followed, I took weekly trips to the state capital of Jackson. It was a 7-hour round trip from Tupelo, working to convince legislators to change the law. We didn't go to the government seeking a handout. Instead, we asked the government to get out of our way. In 2005, our efforts paid off. Mississippi's governor signed legislation enabling hair braiders to practice without the burdensome government-mandated classes. The only requirements now are that hair braiders must pay a 25 fee to register with the state and abide by all relevant health and hygiene codes. Since the restrictions were lifted, more than 800 women provide for themselves and as hair braiders, taking once underground businesses legit and opening new enterprises in place where customer demand was once unmet. And because of the change in Mississippi's laws, aspiring hair braiders are moving here from nearby states, including Tennessee, Alabama, and Arkansas. Freed from the needless government-created barriers, I have gone on to teach more than 125 individuals how to braid hair. No longer blocked from putting industrious individuals to work, I have employed 25 women, enabling them to provide for themselves and their families. For many of these women, the money they earn from braiding represents the first steady paycheck they have earned in their entire lives. Thank you for holding this hearing. To alert the public to this problem, I hope lawmakers in every state across this country are paying attention and will heed our calls to remove the laws that do nothing to prevent honest competition in trades from coast to coast. Thank you.
Thank you, Ms. Armstrong. Eloquently said. Our next witness is Tim Sandifer, Principal Attorney at the Pacific Legal Foundation. Mr. Sandifer has successfully challenged various state laws that unfairly inhibit entrepreneurship in California, Oregon, and Missouri. In addition to his work with the Pacific Legal Foundation, he is author of 3 books that examine how government regulation inhibit economic liberty. Mr. Sandifer, thank you for being here. You may begin.
Thank you very much. You know, we're here discussing the right to earn a living without unreasonable government interference, which is the most neglected civil right in America. The right to earn a living without unreasonable interference from the government was protected by English and American courts as far back as William Shakespeare's day. But unfortunately today, lawmakers and judges typically turn a blind eye to this right, and it gets sacrificed by agencies that are acting often in the best interests of established firms. Today, 1/3 of all occupations requires government permission in order to go into a business. Even a business like being a florist in Louisiana, you have to get government approval before you can do this. Now, licensing laws were originally invented to protect consumers against shoddy or incompetent or dishonest practices, and research shows that they're not really that effective at doing that, but even so, that's at least legitimate. Unfortunately, these laws are frequently abused by established insiders to prevent competition by raising educational requirements, raising the costs of examinations, increasing continuing education requirements, forcing people to get college degrees before they're allowed to take the application examination, and other kinds of requirements that lower access to services to consumers, raise prices to consumers, and what is most important to me, restrict economic opportunity, typically to those who need it the most. For example, you have to have a college degree to be an interior designer in Florida. Well, 47% of blacks and Hispanics have college degrees in Florida, and 66% of whites do. So, not surprisingly, a restriction like that tends to have a racially disproportionate impact and a class disproportionate impact, restricting economic opportunity for precisely those people who most need entry-level employment and what we used to call the American dream. Even more absurdly, people don't really rely on occupational licenses that much to protect themselves as consumers. More often, they rely on reviewing websites like Yelp or Angie's List or word of mouth from friends who have gone to a business and been treated well or badly there. So they're not really very effective in the first place at protecting the public. But these restrictions that limit people from entering into trades unless they receive high educational requirements, or I mentioned testing costs. A lot of the times these examinations to get a license are held in inconvenient or distant places. The examination to get a license as a florist in Louisiana, for example, is offered only once quarterly in Baton Rouge. So if you live somewhere else in Louisiana and you want to be a florist, you have to pay for travel and lodging expenses in addition to the cost of taking the examination, just because you want to arrange flowers. Another kind of licensing restriction that doesn't get enough attention is the Certificate of Public Convenience and Necessity law. This is a licensing law that on its own terms is not intended to protect consumers against dangerous or dishonest business practices, but exists explicitly for the purpose of protecting established firms against legitimate competition. Just last month, I won a lawsuit challenging the constitutionality of Kentucky's licensing law for moving companies. That state, like 22 other states, says if you want to go into the business of being a mover, you first have to get permission from all of the existing moving companies in the state. You file your application to run a moving company. All the existing movers are notified and are allowed to file objections against you getting a license, and guess what? They typically do. The government then, once an objection is filed, decides whether there is a, quote, public need for a new moving company. How do you determine this? Nobody really knows. The statute doesn't explain. No regulation or case law defines the terms. It turned out that between 2007 and 2012, 39 people had applied for licenses to run companies. 19 of those had received objections, and every single objected application had been denied by the state, including license applications from fully qualified movers. One guy who had worked as a mover for 35 years before seeking his own license to start his own company was denied in a written opinion that said, "You're fully qualified, but you would compete against existing movers, therefore denied." And we were very fortunate that Pacific Legal Foundation was able to secure a court decision declaring that unconstitutional. But that's certainly not the final word. Other courts have upheld these kinds of restrictions, and there's no Supreme Court precedent on it since the 1930s. These restrictions are costly. In fact, to prove that there needs to be a new moving company, you were required to hire an attorney to attend this hearing. You're not allowed to represent your own company. There are restrictions on economic freedom that do not protect the public, often on their own terms, and are unnecessary. As in my written testimony, I explained some routes of what the federal government could do to protect economic liberty more through a new federal civil rights legislation, which is badly needed to protect the right to earn a living, using Congress's spending power to require states to respect the constitutional right to earn a living, a right Supreme Court Justice Douglas once called the most precious liberty that man possesses. Thank you very much for this opportunity.
Thank you. Our next witness is Patty Morrow. She is president of Interior Design Protection Consulting, a public affairs firm that assists small businesses in fighting state occupational licensing laws for interior designers. Prior to starting her firm, she owned and operated her own interior design business in New Hampshire before moving her family to Greer, South Carolina. Thank you for being here, Ms. Morrow, and you may begin.
Good morning, Mr. Chairman and members of the committee. Thank you so much for allowing me to speak here today. Like many other interior designers, I entered the field as a second career. In 2004, when my children were 10 and 13, I enrolled in a 2-year program at the New Hampshire Institute of Art. It was an interior design program. There were about 25 women in the class, and we were all second career changers. As I was nearing the end of the interior design program, a licensure bill was introduced in the New Hampshire legislature. If enacted, this bill would have destroyed my dream of having my own interior design business. In order to legally practice, I would have had to go back to school, earn another 4-year bachelor's degree in interior design from an expensive, privately accredited college. Well, number one, there were no such schools in New Hampshire. And then not only that, but since I was going part-time, it would have taken me about 8 years before I could have completed that program. Also, I would have had to pass the burdensome NCIDQ, National Council for Interior Design qualification exam. This exam has historically had a less than 40% passage rate for all 3 sections taken at the same time, and it can cost over $2,000 to take once you consider the cost of the exam, the cost to travel to take the exam, and the cost of study materials. I would have also had to complete a lengthy internship under one of these NCIDQ certified designers. Well, there were only 25 in the whole state, and there was really no guarantee that even these 25 wanted to or were financially able to hire an intern. This bill would have put not only me, but most of all of the other interior designers out of business in that state. And why? Well, the bill claimed it was to protect the public, but I wasn't buying that, so I did my own research. And you know what I found? There's not a shred of evidence to warrant a conclusion that the unregulated practice of interior design places the public in any form of jeopardy. In fact, 13 state agencies have already looked at this issue. They issued reports, and without exception, every single one concluded that interior design regulation would not add anything to protect the public beyond measures that were already in place. Since 1907, only 52 lawsuits have been filed against interior designers in the entire country. That's over 100 years. And nearly every single one of those involved contract disputes, not safety issues. That New Hampshire bill had nothing to do with the public good, but had come about solely through the efforts of industry insiders who were asking the legislature to eliminate their competition and grant them a monopoly. I was not going to just sit back and let this small interest group dictate who could and who could not practice interior design. So I organized a grassroots group of interior designers. We attended the hearing, we testified against the bill, and we soundly defeated it in March of 2007. Then 2 years ago, I moved to South Carolina, and it was deja vu all over again. In the last 2 years, I've had to travel to the state capitol multiple times to meet with legislators, to testify at hearings, all this time taking time away from my business. As of right now, that bill has been tabled. But for how long? Licensing interior designers is a job killer. For the last 8 years, because I'm passionate about this, I've been helping interior designers all over the country protect their right to practice. 80% of interior designers are small business owners. 40% are sole practitioners. 84% of interior designers who are practicing do not have a degree in interior design. And licensing disproportionately excludes minorities and second career switchers. If there's a happy ending to this story, it's this. Since 2007, over 150 state bills which would have expanded or enacted new interior design regulations have been defeated. But like zombies, they just won't stay dead. In conclusion, Mr. Chairman, members of the committee, let me just say that when Barack Obama was elected president, he did what many other presidents did before him. He redesigned the living quarters of the White House. Now, the District of Columbia does have full-blown licensing laws for interior designers. But who did he hire? He hired Michael Smith, an unlicensed designer from California, to do this work. Now, I submit to you, if the most protected person in the entire world can hire an unlicensed interior designer, shouldn't everybody else be able to? Thank you very much.
Thank you. You're welcome to move to New York anytime you like. For the next witness, I yield to Ranking Member Meng.
Thank you. Actually, in New York, the state laws for interior designing are more lax, so I welcome you too. It is my pleasure to introduce Professor Rebecca Hall, a law professor at Vanderbilt Law School. She's a specialist in antitrust law and is focused on changes in professional licensing. She has recently released an article focused on licensing and the Sherman Antitrust Act. She was previously a fellow at Harvard Law School and also clerked for Judge Richard Posner on the U.S. Court of Appeals for the Seventh Circuit. She has degrees from Yale, Cambridge University, and Harvard Law School. Welcome, Professor Hall.
Thank you, Chairman Hanna, Ranking Member Meng, and members of the subcommittee. Thank you for inviting me here today. To someone who studies antitrust, the state of professional licensing in this country is shocking. Licensing requirements are created mostly by boards that are dominated with competitors. They get together and agree on how many competitors they'll face. They agree on who those competitors will be. Essentially, these boards are cartels, with one important and dangerous exception. They are much more powerful. They don't have to worry, as most cartels do, about entry from competitors. They control that entry. They do not have to worry about cheating on the cartel, since their rules are backed by the police power of the states. Since states have basically given professionals the reins to their own competition, one should not be surprised that self-dealing results. Yet some of the licensing restrictions are shocking, as my fellow panelists have illustrated. I want to speak a little bit about what the economists have said about licensing, because that's just as shocking as some of the restrictions we've heard today so far. Economists say that licensing is huge and it's getting bigger. It used to be in the 50s that 1 in 20 people needed a license to legally perform their profession. Now that number is more like 1 in 3. And licensing tends to raise prices to consumers. So, for example, in some states, dentists must hire a maximum of 2 hygienists. This is at the peril of losing their license. In states where the number of hygienists that may work with a dentist are restricted, dental exams are 7% more expensive. Economists have estimated that this results in hundreds of millions of dollars that every year could be in consumers' pockets. Consumers, of course, aren't the only ones who lose out. Licensing makes it impossible for many would-be practitioners to enter the market, effectively reducing their wages and deterring entrepreneurship. But is licensing a bad thing? Certainly not all licensing rules are harmful. Some improve service quality and public safety enough to justify the costs. These are the licensing restrictions that tend to solve the information issues and other problems that make a totally free market for professional services dysfunctional. But there's a lot of economic evidence that many licensing restrictions have no effect on service quality. And the way that professional licensing is currently done, through practitioner-dominated boards with the fox guarding the henhouse, no one has the tools or incentives to balance licensing's economic costs against its benefits. Here is where I see a role for federal law. Federal antitrust law, as it exists now, is designed to balance these economic considerations. And there are many antitrust precedents striking down similar restrictions when they're passed not by a board in a licensing context, but by purely private cartels. Antitrust law could be a powerful tool against the excesses of state-level licensing. But most jurisdictions have interpreted the antitrust statutes to shield licensing boards from antitrust liability. The law here is complex, and I'd be happy to go into it in the questions, but suffice it to say that most courts have allowed licensing boards to operate immune from antitrust liability, and that has meant carte blanche to regulate to their own benefit at the expense of the consumer and the excluded professionals. But last year, the Fourth Circuit became the first appellate court to deny a licensing board immunity and to declare that one of its licensing restrictions violated the Sherman Antitrust Act. That created a circuit split, and the Supreme Court will review the case next term. It has granted cert in that case. I feel strongly that the court should affirm the Fourth Circuit's opinion and make it clear that because of the self-dealing that inevitably happens when you give competitors the reins to their own competition, practitioner-dominated licensing boards should have to answer to the Sherman Antitrust Act. And that's because I think antitrust is not only an appropriate, but the best way to balance the economic costs and benefits of licensing restrictions. Thank you.
Thank you. Mr. Standifer, part of what hasn't been talked about today is the effect this has on the growth of government. I'm assuming that for every license, there's someone behind a desk someplace that's managing the testing, the whole process through that. Can anyone give me an idea of how you feel that affects the overall growth and scope and cost of government?
Yes, thank you very much, Mr. Chairman. The public choice economics predicts that when existing firms have the opportunity to inflict burdens on entry and impose costs on their potential competitors, they're going to exploit that opportunity whenever it's worth it financially for them to do so. And so what you find is not only do licensing agencies employ a lot of people, inspectors and so forth, to make sure that people are complying with these laws and running sting operations and things like this, but you find that existing firms will also waste their money in policing their rivals. They'll watch what the other firms are doing or potential competitors are doing with money that could be spent on helping consumers and producing a better product. As you know, I mentioned sting operations. We see police departments setting up sting operations for unlicensed movers in order to arrest people for running a moving company without a license, when these police officers could be out there actually solving real crimes. Mm-hmm. And these kinds of costs, if you put them together and consider what they are nationwide, they must be tremendous. But I don't know of any actual numbers that have ever been done on that.
Ms. Hall?
Yeah, I have something to add to that. I absolutely agree with everything that Mr. Standifer has said. But also, I think the real question is, how does this affect the scope of regulation, not so much the scope of government? Because to me, these boards aren't government. What they are a bunch of private competitors getting together to agree on entry and agree on rules. So what I'm worried more about than the expansion of government is the expansion of regulation in this area.
Mm-hmm. Thank you very much. Let me ask you a little bit, anyone who wants to answer this, but implicit in all of this process is that somehow there's some public good attained. Then we have something called free enterprise that clears out its own market. Bad actors get in. People find out about their reputations, good or bad, they grow or leave the market. So the assumption under all this, to me, is that somehow government intervention improves that process, keeps people out who otherwise shouldn't be in, and helps people enter the system who are somehow better or likely better at whatever it is they want to do. I don't buy that personally, but I'm interested in how you feel about, Ms. Hall, how you feel about letting the market be the market versus things like Angie's List, et cetera, versus government trying to figure out that market in advance of free enterprise doing it on its own.
So economists tell us that there's two possible reasons why a free market for professional services won't work, and that's information asymmetries, which means that I, as a consumer, have less information than I really ought to have in purchasing a service. And then something called externalities, which means that when I purchase this service and it turns out badly for me, I'm not the only one who suffers. So this is why we license engineers. So if I purchase engineering services to build a bridge and that bridge collapses, well, maybe I got a cheap engineer, maybe I got low quality service, but the real problem is that I don't internalize the costs when it collapses. Mm-hmm. So what this suggests is that a licensing restriction needs to address only serious problems of externalities and information asymmetries. When we think about professions like interior design or hair braiding, we have a lot of information about these services with the advent of things like Angie's List and other services on the internet. And it's hard to imagine a really terrible externalities story where, you know, if you didn't like the decorating that you had done to your house or you weren't happy with that particular hair service, it somehow proves to be a disaster for society. So certainly I think there are some professions that ought not to be licensed, and even within the professions that ought to be licensed for the reasons that I said, sometimes they go too far.
Ms. Standiford, that's an interesting outline of where the limits begin and, I guess, for you end. What would you say to that?
First, the problem with the information asymmetry argument in favor of government regulation is that it presumes that the government has more information, which it generally does not. The government officials don't know how to run a moving business, for example. So what the government agencies then do is they then recruit existing firms to give them that information, in theory. And that's just what leads to the antitrust problems that Professor Hall was talking about, is that then these entities get taken over by the industry in the name of getting the kind of information to protect the consumer. And in fact, information asymmetry problems can be solved better by private certification routes and private review alternatives like Yelp or Angie's List and so forth. As for externalities are taken care of by health and safety regulations that are routine already that say anybody doing this business, whether you have a license or not, if you hurt somebody, you're liable for that. Plus, the information asymmetry and externalities, those are not the only two considerations. The more important and usually ignored consideration is rent seeking. That is, the exploitation of government power by established firms to exclude their competition. And this all sounds all very technical and economic and modern, but it's actually very old. And it goes back to one of my favorite cases in the law, a case called the case of the upholsterers. Now, Ms. Morrow was talking about licensing of interior decorators. There was a case about licensing of interior decorators in, I think it was 1615, called the case of the upholsterers, where there was a law that said you couldn't practice upholstery without permission of the upholstery guild. And it was challenged in court. And one of my great heroes, the judge Sir Edward Coke, declared it unconstitutional under the British Constitution. He said, "No skill there is in this, for a man might learn it in 6 hours." And people said, well, but it still it protects the consumers. And he said, unskillfulness is sufficient punishment. Mm-hmm. That is probably my favorite line from any court opinion. Unskillfulness is sufficient punishment. If you're bad at your job, people won't hire you. They won't shop from you. That's a far better protection of the consumer than creating a government apparatus that gets taken over by established firms who use it to exclude competition, hurt consumers, and bar entrepreneurs who need economic opportunity.
Mm-hmm. Although government may be the one place where you're protected when you're not good at your job.
Or with government power. That's right.
Thank you. Ms. Armstrong, you mentioned that there are hundreds of people who are become independent, become entrepreneurs, have that sense of pride. Maybe give us a couple of cases, because at the end of the day, that's what this is all about, and unleashing the energy, the enthusiasm, the entrepreneurial nature of human beings to become self-reliant, to be able to engage their own juices in their own success, and government's holding that back. Maybe you got a couple of, I mean, your own story is remarkable. I give you a lot of credit, but other people who you know, maybe one or two examples for the committee.
Sure. There is Nine Alliance, and Nine Alliance, when she graduated from high school, wanted to be a professional hair braider, but learned quickly that without the cosmetology license, she was going to not be able to do that. And so she chose instead to go work into a factory. I happened to meet Nine Alliance around about the time this was all taking place, and after the law was passed, she then came out of the factory, not wanting to be there anyway, and came and worked in my salon. And she is a very talented, gifted hair braider. And so she was able to, to pursue what she had wanted to pursue, 20 years prior. There's also Levita Warren. She's down on the coast of Mississippi, and she owns a braiding salon called Braid Baby. As a matter of fact, she had opened a second location, and this is something that, as a result of the law being passed, enabled her to be able to do this.
These are taxpayers. I mean, these are the people we need. And Ms. Morrow, you want to add anything to that? I wonder, implicit in all this regulation is somehow somebody's being protected. Maybe like push back on that if you want it. Do you? Because we're trying to. The suggestion is somehow there's bad interior designers out there creating ugly homes or something. I don't even know. But is there any reality in any of that? Is there, what do we,
well,
no.
To paraphrase Oscar Wilde, no one ever died over the wallpaper. And there is no evidence whatsoever that unregulated interior designers are harming the public. There are 3 states that actually have full-blown licensing laws, and this is after more than 30 years of the proponents trying to get licensing laws. And after all that time, there's only 3 states. There was a 4th one. Alabama's was struck down, declared unconstitutional. If interior designers were being harmed or killed, certainly we would have laws in far more than 3 states. There would be the 47 states that don't have licensing would at least have some. And the licensing laws, the bills that are introduced, you would not believe how far-reaching they are. I'll just read you a couple of things that if you don't have the right credentials, you can't do designs, drawings, diagrams, studies. You can't consult with clients. You can't offer space planning. You can't recommend furnishings. You can't draft contract documents. You can't research or analyze a client's requirements. How do you do interior design without those things? You could not even give customers a recommendation as an employee of Home Depot if some of these laws were to pass.
Mm-hmm. And if I may add to that, Mr. Chairman, that a lot of these laws are backed up by criminal penalties. Is that the case in your situation?
So you can be jailed for bad floor design or something like that. Ms. Hahn, so that we get this straight, more harm is done with these laws than without them. Maybe, can we say that in certain cases? And I'm interested, you seem to have a pretty clear idea of where you would draw the line in terms of who should be licensed and who shouldn't. I think all of you probably do to some degree. Can you generalize about that? I mean, what is the point you would say, or maybe there's a couple of industries that are examples, but go on. What do you think?
So this is why I think antitrust is such a great tool for this particular question, because to me it really is an economic argument that the markets fail. And if the markets fail, then maybe we need regulation and maybe we need licensing. So if we back it up and we ask the question to begin with, is a free market in this area failing? I think you'll find that for a lot of the currently regulated professions, that's not true. I think you'll find for the professions in which a truly free market may fail, a lot of the restrictions go too far and they address market failures that aren't there. So the question that I would ask is this the kind of industry in which we're likely to see a lot of information asymmetries? Is this the kind of industry in which we have a big problem with externalities? Then the second question would be, does the restriction that we're considering, not just licensing generally, but this particular licensing restriction. So you want to license, let's say you want to license dentists. Well, how many hours of schooling are you going to require? What level of education are you going to require? What's the exam going to look like? Every one of these questions should be answered with the market failure in mind, and it should be allowed only if that particular regulation addresses that market failure.
Mm-hmm.
Mr. Chairman, the free market works very, very well in the interior design industry. Consumers are very savvy these days. They have many means to investigate the qualifications of interior designers. And not only that, but there are many private organizations that do different credentialing. And if an interior designer wants to be distinguished from his or her peers, they can certainly take one of the exams, and after it's passed, they can market those credentials, and if they get the job based on that, then they've put that work into their own
People
career.
build a body of work, they build a reputation in the community they live in, and people can decide to hire them or not.
Exactly.
So the fundamental piece of this is government better at deciding who you want to have as an interior designer, or are you in your own market? And clearly, failure is that thing which clears out the market that the government is assuming it's doing by not licensing certain people, but may in fact be limiting competition in a way that could actually encourage less qualified people who are able to get over those hurdles to have access where people that are equal might not. Is that fair, Mr. Sanders?
Yes, it's absolutely. Habit. I almost called you Your Honor. Yes, Mr. Chairman, that's exactly right. And the Supreme Court has made clear in every decision on this issue that restrictions on entry into a trade must be related to a person's fitness and capacity to practice the trade or profession. The first Supreme Court decision on the constitutionality of occupational licensing laws was Dent versus West Virginia in 1883, I think it was, about medical doctors, and that was written by Justice Stephen Field, who declared that licensing laws on the entry into a profession are constitutional if they are related to the trade and they are attainable by reasonable study and practice. But otherwise, they would violate a person's constitutional right to earn a living. The most recent decision on the question, Schwer versus Board of Examiners in 1957, struck down the effort of New Mexico to bar members of the Communist Party from practicing the law. And the Supreme Court again said, licensing laws can be used to protect consumers, but they must rationally relate to a person's fitness and capacity to practice the profession. Unfortunately, I mentioned the Certificate of Public Convenience and Necessity laws for the moving industry have no relationship whatsoever, even on their own terms, to a person's capacity to practice the business of moving. They are written in such a way as to deny qualified movers the opportunity to enter simply because there are already enough movers in the minds of bureaucrats. Now, how do bureaucrats determine how many movers there ought to be in a market? They don't even do consumer assessments or research or surveys or anything. The entrepreneurs often do, but that's not enough to persuade the bureaucracy. And a lot of these laws are written in very vague terms. Nevada, which their licensing law for movers, is the most anti-competitive licensing law in the country. It says you can only practice the trade of moving if it would, quote, foster sound economic conditions, end quote. What does that mean? Well, last year I was at a hearing in front of the Nevada State Senate Transportation Committee. The head of the Department of Transportation was asked, what does that mean? And he said, and I quote, "You know it when you see it," end quote. Now, that kind of discretion in the hands of bureaucrats means it's going to restrict opportunities, it's going to raise prices, it's going to restrict the availability of services, all solely for private interest of those politically powerful movers who don't want competition. It's unconstitutional and it's unfair.
Thank you. I appreciate your indulgence in me, Ranking Member Mangum, if you have. Thank you.
No problem. Piggybacking off that question, and anyone is free to answer, much of the application of antitrust law in licensing cases falls on whether the licensing board is an entity of a state. Can you please explain how the makeup and structure of various licensing boards could be changed so that antitrust law would apply to them? And how could simply reforming the structure of a board help entrepreneurs gain access to more occupations?
Well, I actually think that the way that boards are currently comprised, as they are right now, in most cases, they are subject to antitrust law. So this is where we get into the controversy that's at play in this Supreme Court case, the North Carolina State Board of Dental Examiners. So most boards, we did some research into boards in Tennessee and Florida, are dominated, which means there's a majority of members holding the board, members holding seats on the board, are of the profession, licensed people of the profession. In Tennessee, it's 90%, I think it's 93% in Tennessee, and in Florida, it's 90% of boards are this way. Under a correct interpretation of the state action immunity that I referred to, those boards should be subject to antitrust law. This is what I believe from my research. It's what the FTC believes, and now a circuit court has decided that. What we need is a Supreme Court case to come in and say these boards, as they're currently comprised, are subject to antitrust liability. So it's not a question of changing. You wouldn't need to change the way the boards are organized in order to get that antitrust liability. Now, likely, if the boards, as they're comprised now, start seeing more antitrust suits when these floodgates open, as they would in the case of if we got a favorable decision from the Supreme Court, it may be true that the states will alter how they do their regulation. They may actually change the composition of those boards, and to my mind, that's a good thing, because what they would have to do is they would have to remove that, at least, the very least, they would have to remove that majority on each board of the practitioners.
Besides the legal and health fields, what are some of the most common licensed professions that you've seen around the country that are overregulated? Where can states ease regulations in some of these fields?
It's hard to answer what trades are the most commonly regulated, because you find that typically all the states impose regulations, and then there's some that are contentious, like florists is only in Louisiana, and then there's varieties of licensing requirements, as in like with interior designers. It's only a violation of your First Amendment rights and not of your 14th Amendment rights. That is, it only says you're not allowed to call yourself what you are, but you're still allowed to do that practice, for example. So it's hard to answer that question. But industries like in my business at running the Economic Liberty Project at Pacific Legal Foundation, we have focused a lot on the moving industry, because this is an entry-level industry that has low startup costs. It's a great opportunity for people who don't have much work experience or education, and yet they are licensed in the same way that natural gas pipelines and railroads are licensed, which is absurd. And that's in, as I said, 22 states in this country regulate the moving industry in that way. And then there's lots of cities and counties that impose similar kinds of regulations. I think the way I would answer your question is that the Certificate of Public Convenience and Necessity law for ordinary competitive markets should be abolished entirely. There is no rational justification for allowing existing firms to veto their own competition in a perfectly normal competitive market like moving or taxi cab operations. Or these laws even apply to hospitals. If you want to start a hospital, you can't start a hospital if the existing hospitals don't want you to. Or buy medical equipment. We're talking about people's lives now. The island of Maui, a few years ago, it only had one hospital operating on the island, run by the state. And which meant that if you were injured far away from that hospital, you'd have to endure a long ambulance ride to the hospital. So some people got together and said, let's start a second hospital. State denied them a certificate of need to open a new hospital for several years. It has since been granted. But when you consider the fact that in an emergency, every second counts, that means it is very likely that there is somebody who is dead today who would not be dead if the state of Hawaii had not decided that it was more important for them to prevent economic competition against their state-run hospital. So my answer to you would be that the Certificate of Public Convenience and Necessity law should be radically scaled back or abolished entirely. And the federal government can do that, either as a condition of spending clause budgetary matters or through federal civil rights legislation, which, as I said, is sorely needed in this area. The first federal civil rights law in 1866 was primarily focused on protecting the right to contract and the right to private property. And we've lost sight of the importance of those rights in just the past few decades. And I think it's really important for Congress to consider that that hurts precisely those minorities who most need that kind of civil rights protection.
So Mr. Sandifer provides some shocking testimony there, and I can shock, but maybe in a different way. So there are 1,100 different professions that are licensed in at least one state, and I could be here for the rest of this hearing listing these, but I'll just give you a few. Locksmiths. This means it's illegal to do this unless you have a government-issued license. Locksmiths, beekeepers, fortune tellers, tour guides, shampooers. This list goes on and on.
Fortune tellers, even though it is literally impossible to be a competent fortune teller.
I think we need to have another hearing to determine if that's true.
Just to play devil's advocate, in New York City, many areas, for example, you talk about moving companies. We've heard of lots of stories where moving companies will sort of prey on people within certain communities. They will come and move and steal their people's furniture, so people never see them again. They will taking up parking spaces, and there's no way to contact them or to hold them accountable, parking illegally. And so how do you balance the interests of consumer protection and over-regulating moving companies, for example?
The reason I'm smiling is not because that's a bad question, but because I'm actually in a dispute with my moving company, which just started yesterday, and it's quite tense for me and stressful, and I'm having to deal with this exact problem myself. And there are perfectly normal remedies. I could have hired a different company. I can review them badly on Yelp. I can sue them if they break or steal my things. We can call the police department and if they steal my things or whatever, and so forth and so on. There are plentiful regulations. You're never going to have a regulatory system that will stop all harm. And these Certificate of Public Convenience and Necessity laws have no connection to that. It's true. You have to prove that you have to satisfy the bureaucracy that you would comply with the law in order to get a license, but that doesn't prevent you from breaking the law if you choose to. So these kinds of laws are not effective at protecting the public, and protecting the public is more effectively, although not perfectly, done through other avenues of the law. Now, as far as New York City is concerned, you are almost certainly aware that in the 1930s, the city of New York capped the number of taxi cab licenses at, I think it's something like 30,000, 13,000? I don't remember the number. Anyway, cap the number of available taxi cab medallions so that today there are as many cabs or fewer almost that in New York City than there were in the 1930s. So that today a medallion to operate a single taxi cab in New York City costs $1 million. Now, it ain't rich white guys driving taxis, right? So if you want to run a taxi company, what you have to do is lease your license from the few wealthy people who are able to afford them. And that means that you're working from Monday until Thursday or so to pay off the hundreds of dollars a week that you have to pay for the lease of the license on your taxi cab, and then you get to keep the money that you earn otherwise. And is it any wonder that these licensing laws, not only do they harm the poor and entrepreneurs, but they push people into the underground economy or even deter them from getting a job in the first place because it's just too hard and they can't imagine themselves getting that.
Several states have begun to offer better reciprocity between their licensing regulations to enable workers to start working immediately following moving to a new state. This is especially beneficial for military families. Besides offering portability to increase worker mobility across state lines, what else can be done to rein in licensing laws?
Well, I would say that legislation that makes clear. I would suggest something modeled on the Religious Freedom Restoration Act or the Religious Land Use and Institutionalized Persons Act that would say that restrictions on the right to earn a living must satisfy a high threshold for constitutionality. Another one would be what's being called sunrise legislation. It's similar to sunset legislation. Sunset legislation says a bill will expire unless it's renewed. Sunrise legislation says to the legislature, you have to satisfy these standards in order to impose a new licensing restriction. There's a bill like this in Missouri right now. I just testified in a committee there just a couple of weeks ago. And they're not binding. They don't actually prohibit the legislature from restricting or imposing a new licensing restriction, but they include certain factors that have to be proved before the legislature will impose these restrictions. And there's significant ones. They say, prove that there's no free market alternative available, and so forth and so on. I think those are good. Those are good ideas for reform.
What I would like to see is the correct interpretation of the state action doctrine prevail in the Supreme Court. And what that would mean for probably around 90% of boards in the U.S. is that they would be subject to the antitrust laws and would have to balance the anti-competitive effects against the pro-competitive effects.
Thank you. I yield back.
A couple of quick questions. What do you think this costs the economy in terms of job creation? We have an example in a relatively small community of hundreds, right? And in general, job creation. Anybody? You've talked to economists, Ms. Hall, maybe.
Yeah, I know that, so some of the figures that float around are licensing costs $100 billion to consumers. That doesn't directly address the question of job creation, but it's going to be related to that, right? So a statistic that I think is relevant here is licensing tends to raise wages for the incumbent professionals. The figure used to be about 10 to 12%. Modern data now says more like 18%. So if we want to think about that as how it would affect job creation, you can think about that as, raising the minimum wage or something. There's only so many places these dollars can go. So that's going to constrict the labor supply as well.
It's really impossible to answer that question any more clearly than that because of what economists call the broken window fallacy. The kind of costs that are being imposed by licensing restrictions are in the form of jobs that just never appear. So how do you measure that? How do you measure the number of people who say, "Oh, I'd like to start a moving company, but it's impossible to get permission, so I'm not going to." And it's impossible to measure that. The reason it's called the broken window fallacy is it comes from an old story about a baker who arrives at his work one day to see that somebody has shattered his window in the middle of the night. And as he's sweeping up the glass, a friend says to him, "Well, don't worry, it's good for the economy because now you'll buy a new window to replace the broken window." Well, that's nonsense because he was going to spend that money on a new coat. And then he would have had both a window and a coat. But now he only has a window. What you never see is the unseen cost of this vandalism is the coat that is never made and never appears. And so what we have with economic restrictions like licensing laws is how do you measure jobs that are never created or the innovation that might have occurred? The hair braiding is a great example of this because licensing boards define the scope of their practice as broadly as possible to protect themselves from competition. Well, an entrepreneur comes along and says, "Well, I'm not going to be a barber. I've got an idea. I'm going to just braid hair." Well, then the barber and cosmetology board says, no, you have to have one of our licenses. Now, this is an innovative new business model. This is a new idea for a business that has never been around before, but is being forced into this category of barbering that it really wasn't designed for it and was imposed decades ago. Well, we don't know the kinds of costs in terms of innovation and creativity that these licensing restrictions impose. It's literally incalculable.
But what we do know from Ms. Morrow and Ms. Armstrong is that there are literally thousands of people who are held back from doing what they want to do because of restrictions barriers to entry that are so burdensome either don't climb them or they try and they quit. And we know that within that lack of competition by its nature is a cost push. Clearly, no one would be interested in limiting the number of moving companies if it weren't something they thought moved to their own bottom line.
That's right, and you could try to measure the costs of these licensing restrictions by measuring how much time and energy the existing firms put in to restricting their possible competition. In the interior design field, they put in millions and millions of dollars to try and obtain licensing laws that will restrict entrepreneurs from competing against them. In the moving industry, the existing firms would hire lawyers and spend hours in the process of the hearing and filing objections and these sorts of things in order to block competition. Mm-hmm. So you could measure those kinds of costs and say that is more or less the cost of these licenses.
If someone's willing to spend tens of thousands of dollars to keep someone out of their business, you can be darn sure that it's for a reason.
That's right.
In its profit. Yes, ma'am.
Mr. Chairman, in the interior design business, it is one national trade association that has spent allegedly $8 million trying to get every state regulated. And not only that, but this same trade association, they created the exam that you have to take and then spun it off, and they created the accreditation for the colleges that you would need to take, spun that organization off. So there's these three organizations that have been working together for over 40 years to regulate the whole industry. And we call that a cartel.
Sure. So,
we do too.
Notice. So these manufactured requirements by people who are already in the industry, designed to keep other people out of whatever that is, raise prices, limit competition, limit job creation. What about innovation? I mean, what do you think of that? I mean, that's just a thought.
So Mr. Sandifer brought this up a minute ago, and I think that's absolutely right. So you're seeing a lot of this activity on the part of established boards of broadening the definition of what their practice is. And this, of course, is going to stifle innovation, because anytime you come up with a new business model that's to the side of a profession, suddenly you might find yourself receiving a cease and desist letter that says, oh, no, that's in our profession. Mm-hmm. So we're seeing this with teeth floaters. I guess horses' teeth don't naturally wear down, and so you have to file them. And it's traditionally been done by relatively low level of education, just sort of you learn how to do it from your family business type thing. Well, suddenly veterinarians have decided that this is part of veterinary practice and can't be done unless you have a veterinary license, which of course, as we know, is many, many years of education and passing an exam. And guess what? They don't teach horse teeth floating in vet school. So the case that's actually before the Supreme Court is about teeth whitening. So it was the dentists, the Dental Board of North Carolina saying, teeth whitening in all its forms is part of dental practice. So as you see the definition, not just more and more professions coming under licensing, but the established licensed professions becoming bigger and bigger, you're going to be able to see less innovation on the margins of those professions.
Mm-hmm. My sister was a farrier and did that often. File teeth, and you're right, they just grow forever.
Yeah.
As like rats. So free markets work best. Consequences of what we're describing here today are good and bad. There's good and bad outcomes, but markets have a way of dealing with that. People don't need the government to tell them every little thing they need to know about who they're hiring. And like you said, in terms of moving vans in New York City, just because you have a license doesn't mean you're not a thief, or no more than it means you're not good at what your job is. So with that, unless we have little time, if anyone would like to sum up.
I did have one other point I would make in terms of economic costs, and that is what economists call the Cadillac effect. A Cadillac effect is when government regulation makes it such that you can buy a Cadillac or nothing at all. Right, a restriction that says if you want a car, it must be a Cadillac, and that is often what happens in terms of regulation of professions that say if you want to hire a lawyer, it has to be a lawyer who's gone through this many hours of continuing legal education, or if you want to hire a hair braider, actually you have to hire a barber, and this prices people out of the market and ensures, and that's what causes a lot of black market.
Would you like to comment on Tesla and?
That's an or Uber. Or other examples of the recent headlines in which new innovative business models have been excluded from the market by really obsolete licensing restrictions for taxi cabs or car dealers.
Yeah, and can I just say, a lot of the stuff we talked about today is kind of shocking, but It's also completely mundane. If you asked competitors, who do you want to compete with, they're going to say, as few people as possible. If you're going to ask dealers, do you want Tesla to direct market their cars, they're going to say no. So on the one hand, this is all surprising. On the other hand, to me, it seems really unsurprising.
And it's not new. I mean, I mentioned these 17th century cases. Lord Cook, when talking about licensing laws, said that the people who advocate for licensing laws are like a man rowing a boat. They look one way, but they row the other. They pretend public benefit, but intend private.
You're a man without lack of anecdotes. I want to hit one other theme here because I think it's very important, and that is that minorities and women who I have friends who sell Mary Kay, right? You have friends who do braiding and other things. These are cottage industries that can be done within the confines of someone's existing lifestyle if they can find the time, if they have children, stay-at-home mother. So. I mean, I find it compelling that in your case, Ms. Armstrong, that people are able to become independent through being entrepreneurs and able to probably stay home with their children while they do this. Same with you, Ms. Morrow. So that we're really hurting a class of people, women and minorities. And I'll just throw this out there, if you can confirm it or not, that it disproportionately affects people trying to manage in, let's say, marginal circumstances, that we have an opportunity to help them be transcendent. And through these licensing laws, we're actually hurting the people we're pretending to help in some cases with these laws. Any comment about that?
Yes, and you really hit on something because that is one of the main complaints that the cartel uses. They say anyone can hang out a shingle and be an interior designer. And yes, in 47 states, that is true. But, as I said before, consumers are very savvy, and the needs of the person who is practicing are different too. And you have the person who, wants to do a lower level of design, and you have the person who wants to do a hospital. And the thing is that the person who is responsible, the administrator of the hospital, is not going to hire the person who hung out their shingle yesterday. They're going to very vigorously vet the interior designer who's going to design. So there's different levels, and there's consumers for all levels. And if only the wealthy or only the big businesses could hire an interior designer, I don't think that's right. I think everyone should have good interior design. And it's such a diverse field that anyone can come into it. They can create their own little niche for customers that like what they're selling and that, for as many hours as they want to work and support their family.
So free enterprise works best. Government interference is often the law of unintended consequences, which creates more dislocation and damage economically than it intends. And people use government to protect their own self-interest in a way that keeps others out. And in particular, in Ms. Armstrong's case and yours, stay-at-home moms and minorities and a whole class of people that really aren't in a position to climb over those hurdles that the government's thrown at their feet. So I want to thank you all for being here today. You've provided great input and done a wonderful job, all of you. I ask, there are no further questions, I ask unanimous consent that members have 5 legislative days to submit statements and supporting materials without objection, so ordered. That's it. Thank you.
Thank you very much.